We're now ready to resume. Ms. Crowther.
Yes, my Lord Burrows.
Could I just take you back to the interchange you were having before lunch with my Lord Leggett about the Metal and Rostoff case?
Yeah.
Because I was just a bit concerned that you may have accepted the proposition that there was no damage sustained in that case in Switzerland. And it wasn't clear to me that we can take that from the Metal and Rostoff case. So if I can just refer you to page 2181, which I believe is the only page that actually discusses this, but I'll stand to be corrected. And I've only had a brief time to look at it. But what I took from that discussion was that damage was suffered or regarded as being suffered in London and in Belgium. And what was ruled out was the proposition being put forward by Mr. Grabiner that the damage was wholly suffered in Switzerland. But it certainly wasn't being said that there was no damage sustained in Switzerland.
Yeah, sorry, did I not?
It may be that I misunderstood, but I thought the proposition being put to you by Lord Leggett was that there was no damage being sustained in Switzerland, whereas I think the argument was there certainly was, and the only question was, could one say that there was also damage in London and potentially Belgium?
Yes, sorry. Yes, that's right. I think there's a standing presumption. It's probably me that's misunderstood. So I think probably I may have then not made it clear, but I think you can see the key issues at 433. On behalf of ACLI, it was submitted that the damage had been really in their pocket and it had been wholly at their headquarters in Switzerland. So they were saying that all the damage was in Switzerland.
Right. Okay. Thank you. Because it then led me to be slightly concerned about the distinctions you were drawing between personal injury and pure economic loss, because my understanding would be that one way of viewing a Fatal Accidents Act claim is that actually, because the person who is making the claim is not itself injured, all that loss is pure economic loss in a dependency claim. And therefore, for the purpose of this case, I would have thought it would be problematic if you were starting to accept that there were different approaches to economic loss claims than for the direct loss flowing from a personal injury claim.
My Lord, I'm grateful for the opportunity to clarify. What I'm trying to express, probably ineffectually, is that we don't need to, in the context of this case, worry too much about what happens in the economic tort cases, because we have a clear line of authority, which I'm going to look at next, which is how personal injury and Fatal Accidents Act damages are dealt with in the context of what Mattel did decide. My submission is that because the whole gateway is so wide, it covers all of tort, that is wider than this court needs to trouble itself with for the purpose of deciding this case, which concerns the meaning of damage in the context of this personal injury action. So I wasn't meaning to put it any higher than that. So I'm sorry if I inadvertently did. What I was meaning to say is there are a lot of difficult issues in a lot of different economic tort cases, and it's not always easy to see a clear path through them. But we don't need to engage with those, because the decision in Mattel is clear and has never been overturned and is good law, and as we'll come on to see later, has been relied on in the first instance judgments and was also relied on in the majority in Brownlie last time they looked at this.
Yes, thank you. Although I have to say that, you know, our job is to decide these issues beyond necessarily the facts of the specific case before us if there's an issue of principle. But yeah, thank you very much.
I was going to go next, if I may, briefly to the Commonwealth cases. I know my Lord Reid referred to them. I'm not sure that we need to turn them up particularly. They are dealt with in our written case at page 124, paragraphs 40 to 43. The submission is effectively that England and Wales, it cannot be seen as an outlier in terms of its interpretation of damage. If one looks at Singapore and Hong Kong, they have also followed the same approach, and we've already looked at the Australian authority. Moving on to where we do say there is a contrast is between English law and Scots law. And again, we don't need to look at the 1982 Act directly, although it is in the bundle, and it's the reference to Schedule 4 is 2792, and the reference to Schedule 8, which is the Scots law provision, is 2884. And we deal with it in our written case at paragraphs 28 to 30, and you see that in the electronic bundle at 120 to 121. Essentially, we say that the wording is clearly different. It talks about the place where the harmful event occurred or may occur. That's a deliberate choice by the legislature, made at the same time that the tort gateway was made in completely different terms. And we also rely on the fact that at section 16 and in section 20, subsection 5, of the CJJA, there is an interpretive obligation placed on the courts to have regard to the EU case law with respect to interpreting place where the harmful event occurred. So it's materially different in two respects, the wording, but also the accompanying interpretive obligation. In my learned friend's written case, the observation is made that in Scotland, the forum non-convenience discretion is retained by virtue of the 1982 Act. And the suggestion is that this somehow supports the proposition that the narrow interpretation of the damage gateway in English law should be adopted. We say that just because it is possible to have a system with a narrow rule and forum non-convenience at the same time, it does not follow that just because there is a foreign non-convenience rule, that the gateway must be interpreted in the same way as the European law. It's just not, doesn't follow as a matter of logic. And that's all dealt with in our written case. What I wanted to do, if I may, is have a look at some of the first instance decisions which have considered the gateway. And we could start with Booth and Phillips, please, which is at 3762 of the e-bundle. This was a decision by Nigel Tier QC, and at paragraph 32, he identifies that you've got to look at the question of what does damage sustained within the jurisdiction mean for what was then Rule 6.28, and at that time had a definite article removed because, as we saw in it's set out in our written case in 2000, there was an amendment to the rules that changed it from the damage was sustained to merely damage was sustained. The point we make about that is that we said that reflects the decision in Metal to make it clear that any significant damage sustained was sufficient, and that is why that definite article was removed. And you can see from paragraph 33 that this was a fatal accidents claim, loss of dependency, funeral expenses, as well as damage of the widows in this jurisdiction in her own right, in respect of coincidentally a tort that occurred in Egypt. And at paragraph 35, Nigel Tier starts with the natural and ordinary meaning of the words. He says, I shall start and perhaps ought to finish with the words of the rules themselves. He makes the point I made earlier, there's no reference to damage which completes the cause of action, and also observes that the civil procedure rules are supposed to be simple and simply expressed. I think at one point yesterday, my learned friend may have come perilously close to suggesting that that wasn't the case, that they're not supposed to be simple or simply expressed. I would respectfully endorse that observation by the judge there. And he says that he thinks it should be given its natural and ordinary meaning, harm which has been sustained by the claimant, whether physical or economic. One can see from the head note that the judge had the benefit of Flaherty and Girgis, Metal, Sky Rotors, Spiliada and the Weil and Von Wendt cases cited to him. Then at paragraph 36, he deals with the defendant's objection that the wide interpretation would open the floodgates and encourage forum shopping. And Mr. Justice Tier then says that, of course, it's permissive, and what we've got here at the top of 3763 is a reference to the forum non-conveniens stage of the test, in which the case will be most suitably tried for the interest of all the parties and the ends of justice. When regard is had to this requirement, there does not appear to me to be anything objectionable about the claimant's construction. And then for these reasons, the natural and ordinary meaning suggests that the claimant's construction of the rule is to be preferred. He looks at Metal in 38, and then goes through the Commonwealth cases, Sky Rotors, which we haven't looked at, but is materially set out there, Von Wendt in paragraph 41, and Flaherty in 42, citing the passages to which I've already directed your lordship's attention. And then at paragraph 44, he comes to the application of those principles to the Fatal Accidents Act before him. Her claim stems in her own right from the FAA 1976. It's accepted by the second to fourth defendants that her claim is in tort. She seeks to recover in respect of the injury resulting from the death. Such financial detriment is, in my judgment, damage within the meaning of that word, which was sustained in England where she lives. One element of her claim as executrix, I'm told, is the expenses of funeral which were incurred in England. There was also damage sustained in England. For these reasons, the claimant has established another ground for seeking permission to serve out of the jurisdiction. And then he goes on to consider at some length over the next pages the relevant factors of the forum non-conveniens test, which I don't need to take you to. The next decision I'd like to look at, if I may, is the case of Wink, which is at 2761. And the eagle-eyed amongst you will have noticed that my learned friend Ms. Kinsler and I appeared in this case, although we were on opposite sides of the same argument. So in that case, Mr. Wink had been on a cycling holiday to Croatia. He got badly injured in a road traffic accident. And Mr. Justice Haddon Cave, as he then was, heard the jurisdiction challenge, and we can pick it up at the top of page 2759, at paragraph 19. He sets out the claimant's reliance on the tort gateway, and then and then briefly the arguments which was me at that stage making on behalf of the defendant, and then paragraph 24. He sets out the gateway and then looks at the Booth case, the passages to which I've just taken you, and another case of Cooley and Ramsey, which we don't separately, I don't think, need to go to, but I do refer to it in the written case, and it is a relevant case for your lordships to have regard to. And then at 30, He sets out the submissions made, which would probably be familiar to you by now, about direct and indirect loss. And the analysis starts at page 32. He says the narrow meaning suffers from a number of obvious problems. First is there are no limiting words which would justify the narrow meaning. The word damage is not modified or trammelled in any way. The ordinary natural meaning of the word is any damage flowing from the tort. In the words of Mr. Justice Tier in Booth, damage in this context means any physical or economic harm, i.e. direct or indirect. Second, Ms. Crowther's construction is tantamount to saying that damage is sustained only where the injury occurs. And this is where the defence argument was originally put, but this is not the case in many instances. In the present case, is a paradigm example. Sequely, flowing from the original accident in Croatia, continued to be suffered long afterwards in England in the form of substantial pain and suffering and economic loss. So there's a direct finding of a continuing suffering once the claimant had returned from his holiday in Croatia and was resident again in England. And I reject Ms. Crowther's submission that the meaning by tier it means some damage, direct or indirect, because that requires rewriting or additional words to be inserted. Indeed, it's Ms. Crowther's construction which requires rewriting of the subparagraphs to substitute the words the injury for the damage, or to substitute the injury was sustained within the jurisdiction. Such a rewriting would be unwarranted. And then he rejects at 37 the idea that it was damage which is sufficient to complete a cause of action, based at that time on arguments from Harding and Whelans. And he says it's not, as Ms. Crowther argued, capable of division by reference to direct and indirect losses. The fact that the tort may be complete on proof of some loss or damage does not mean that jurisdiction cannot properly be founded by proof of some of that loss or damage occurred in the jurisdiction in question, and he relies on Metal in support of that. And he then deals with the other arguments that it's too uncertain and that it's exorbitant, and right down to his conclusion at paragraph 43. And then again, he goes on then to consider forum non-convenience. So again, I would commend that judgment to your lordship's attention. It's clear that Mr. Justice Haddon gave it specific and detailed attention. He didn't simply follow what Mr. Justice Tier had previously done in Booth, or indeed what had happened in Cooley. And the case was fully argued in a way that might, by this stage, be beginning to seem rather familiar in this long string of cases. In fact, familiar in this Brownlie case itself. And so we submit that there's plenty of support for our proposition that the natural and ordinary meaning of damage in the context of personal injury and wrongful death claims is wide enough to encompass what Mr. Justice Nichol found in this case was that Lady Brownlie had indeed suffered significant damage in the jurisdiction, and the tort gateway is met. There are some other first instance decisions which we needn't necessarily go to, but the point is that all of the first instance decisions which have looked at this gateway point in the personal injury context have all reached the same conclusion, and they're essentially fully reasoned along very similar lines to what you're being asked to consider now. That was obviously of very persuasive value for Lady Hale in Brownlie number 1. She took the point that experienced first instance judges dealing with these questions had, over a long period of time, reached the same conclusion on this issue. Can I then briefly, if I may please, turn to responding to some submissions about the purpose of the gateway? And my learned friend took you to the Quinterville and Bloomsbury decisions in support of some submissions he made about the principles of statutory interpretation. Our position is that, and is set out in our written case at paragraph 34, which is 122, I apologise, 122. But our position is simply that in both of those cases, the courts were looking at a holistic legislative scheme, which as a whole had a clear purpose and was being invited in both cases to choose between competing meanings, one of which would have clearly fallen well outside that legislative purpose. In Bloomsbury, the one interpretation would have left the word landing with so little meaning as to be useless. And in the Quinterville case, it was rather different again. That was whether the new technique of cloning, which obviously on the face of the words didn't fall within the Act because it hadn't been envisaged at the time of the Act that such a thing as cloning could be done, whether that new technology could, notwithstanding that, be said to be within the scope of the Act by construing it purposively. And if one looks at the speeches of the lordships in that case, you can see that the prospect of cloning either being unlawful or unregulated was not one that they were very happy to countenance. And so a purposive meaning was given to it in order to bring it within the regulatory scheme. All of this is fine insofar as it goes, but we say it really, to a degree, sorry, my Lord Leggett.
I just wanted to ask you, Ms. Crowther, the difficulty I have with your case is what useful purpose the gateway serves. If you're right in your interpretation that you carry your damage with you wherever you go.
Well, it means that people who have damage in this country can bring a claim. People
Well,
who don't have...
It means they can bring a claim anywhere on that basis, subject, of course, to forum convenience, but then it doesn't sift out any cases, does it, really?
I would respectfully disagree, my Lord. I mean, it would be limited to those cases where people had significant damage in England. So it would not entitle any person anywhere in the world to bring a personal injury claim in England. It would be merely those people who had suffered significant damage here. So I suppose if on the facts of a particular case, it was felt that the damage was de minimis or insignificant, then the gateway wouldn't be met. And equally, if the damage wasn't sustained here at all, then that claim would be excluded. But there's no reason to think that it needs to be any narrower than that in my submission, because we do have then the key test of appropriateness, which is the forum non-convenience discretion. So the two march hand in hand. They're two stages of the same process. The judge has to consider whether the threshold is crossed, whether in principle this is a kind of case where service out could be permitted, which is fundamentally what we say this rule is for. And if it can, then it goes on to say, is England the appropriate place for the claim to be determined? So there's no risk of forum shopping or grave injustice, or I mean, the courts would be very astute to pick out, for example, someone who'd chosen to move to England solely for the purpose of porting his personal injury claim here if he had no real substantial connection to the jurisdiction. And as I said before the short adjournment, in real life, I think one could take a fairly sensible view about how likely that is to happen in a case where someone's been seriously injured. So we say that the wide meaning is entirely appropriate in line with what we say must have been the intention of the legislature to add damage as a second limb to the tort ground in order to overturn what had been decided in distillers and to make it broader. And the risk, frankly, with the narrow interpretation is almost that you get very close to abolishing the second limb in personal injury cases. Because
that's not true, is it? Because there are all sorts of cases, well, but maybe in personal injury, but there'll be there are many cases where the injury is sustained in a different place from where the act is done.
There may be.
There's nothing to suggest that this has to apply in personal injury cases when it applies across the whole of tort.
Well, my lord, I was very careful in my choice of words. I didn't say that all personal injury cases would be eliminated, and one can always think of examples, perhaps latent damage cases, where there's a gap between the breach and the development of the injury. But that's a minefield with respect. I mean, one only has to think about the kind of the Dryden case, where the question of what injury was actionable and at what time the injury had occurred and where you might be when that happened, and the science simply might not permit it. And then you can see people having to adduce medical expert evidence in order to persuade the judge that the timing of when they had damage. All of these things seem to be really, in my respectful submission, completely beside the point, because this is really about jurisdiction, and the rules are a means to an end. And the end, in our respectful submission, is to identify in a general but flexible way the types of case which are permitted to be heard. But it doesn't mean that the court has to hear them. So what we're looking at here is the permissive stage, and we say, and against that background and the cases that we've looked at, the first instance judges in those cases that we've just now seen were absolutely right in their interpretation. I would like, if I may, please, to make some points about the European law aspects of this and the alignment with the European law. Could we perhaps have a look at the Brussels 1A regulation? It's 3270. And the one can see from the recitals the nature of this scheme, starting with recital 15, if I may, please. Rules of jurisdiction should be highly predictable and founded on the principle that jurisdiction is generally based on the defendant's domicile. And we see that reflected in Article 4, which is the general rule. And we'll come on to look at a couple of the European cases, but my submission is that that is a major centre of gravity within the Brussels 1A regulation, the desire to protect the general rule that the defendant's domicile is the place for jurisdiction. Another recital which I submit is here. Oh, sorry, Lord Briggs, I missed you. Sorry.
Is that really a point of distinction? If the general rule in England is that you can only assert or invoke the English court's jurisdiction where you can serve the person, and that without permission you can only serve persons who are here, why is not our basic rule that jurisdiction exists in personam only over persons within the jurisdiction?
That may be right, my lord, insofar as it goes, but I suppose my submission goes a little bit further, that in practice, because there is an inherent need for strict and certain rules in the European scheme, that they have accompanied that basic rule with another rule, which says that exceptions should be narrowly construed. So there is very clear dicta from the CJEU that says that your basic rule is defendant's domicile, and when you're looking at exceptions, then you have to make sure that they are narrowly construed. And my submission is that there's no equivalent legislative interpretive obligation in the gateways, and there's nothing that we've seen in any of the case law that would support that from a common law perspective. I also,
but aren't all the gateways exceptions to the basic common law rule that jurisdiction depends upon service?
I'm not essentially disagreeing, my lord. I think what I'm saying is that my point goes a little bit further, that in the context of the European scheme, it has been held that exceptions have to be narrowly construed, whereas we don't have that case law here. If we can look at recital 18 and 19, which is the top of the right-hand column, the European scheme has special rules to protect weaker parties, that's consumers, employees, and also in insurance. That insurance extends to motor vehicle insurance and third-party victims of motor vehicle insurance, and they have special rules to protect them that are more favourable to their interests than the general rules. I point that out simply to observe that in the context of the Brussels 1A scheme, it's much less common for personal injury victims to need to rely on the general tort gateway, because there are special provisions which give them priority and protection, which do not exist in a comparable fashion in the English law gateways. At recital 21, which is, sorry, right-hand column on 3270. It's in the interest of justice of harmonious administration to minimise the possibility of concurrent proceedings and to ensure that irreconcilable judgments shall not be given in member states. This is a significant preoccupation of the Brussels scheme, because it is largely about allocation of jurisdiction between the courts of member states. So on the one hand, they seek to have clear and certain rules of allocation, and on the other hand, that their enforcement mechanism is then that those judgments, once obtained, are effectively passported all around Europe. So in order to facilitate the free movement of those judgments, they're creating a holistic scheme which is allocating between member states. We can see, and this is a point which is made by Lord Wilson in his judgment in Brownlie number 1, at Article 6 of the regulation, which is on page 3274, that if a defendant is not domiciled in a member state, the jurisdiction of the courts of each member state shall, subject to 18, 21, 24 and 25, which are the prorogation of jurisdiction provisions, be determined by the law of that member state. So there's an express reservation for the member states' national laws in respect of jurisdiction cases that do not fall within scope. And as Lord Wilson observes, the issues of mutual recognition of fair hearing rights and mutual trust in the judicial systems of the member states has allowed the European Union effectively to dispense with many of the considerations that used to arise under forum non-convenience. And we see that in recital 15, back on 3270, that the rules of jurisdiction should be highly predictable. We saw that jurisdiction should always be available. And that has been interpreted to mean, in fact, that there's no forum non-convenience discretion. So with that in mind, you were taken to, I think, I can't remember whether we looked them up or not, some of the European cases, Dumes and Marinari, which relate to jurisdiction under the ground, the harmful event ground. Perhaps if we could have a quick look at Dumes first of all, and I've just lost my reference. Sorry, it's 3096. And I would particularly draw the court's attention to paragraphs 17 and 18 of the judgment, which appears on 3113 and 3114. This is where I pick up the point about exception to the general rule about jurisdiction being attributed to the courts of the state of the defendant's domicile. That Title 2, Section 2 attributes special jurisdiction in certain cases, including the case envisaged by Article 5.3, as the court has already held in Bière, they're calling it Minda Potas here, but those cases of special jurisdiction the choice of which is a matter for the plaintiff, are based on the existence of a particularly close connecting factor between the dispute and the courts other than those of the state of the defendant's domicile, which justifies the attribution of jurisdiction to those courts for reasons relating to the sound administration of justice and the efficacious conduct of proceedings. And then at 18, they're going to say, in order to meet that objective, which is of fundamental importance in a convention which has essentially to promote the recognition and enforcement of judgments in states other than those in which they were delivered, it is necessary to avoid the multiplication of courts of competent jurisdiction, which would heighten the risk of irreconcilable decisions, this being the reason for which recognition or order for enforcement is withheld by virtue of Article 27.3 of the Convention. Now, that is not a concern of the English common law. And it doesn't matter to the English common law whether there's a multiplicity of jurisdictions, because we're not trying to generate a judgment that is circulating as part of a free market of judgments. And so that is one of the motivating factors in narrowing down the scope of the tort gateway. It's in order to promote certainty, to reduce the number of possible jurisdictions, and to try to ensure that defendant's domicile, Article 4, keeps its proper place at the top of the hierarchy. And we see a similar pattern coming out in Marinari, which is at 3178. Turning first, if I may, to paragraph 13. The choice that's available to the plaintiff cannot be extended beyond the particular circumstances which justify it. Such extension would negate the general principle laid down in first paragraph of Article 2, that the courts of the contracting state where the defendant is domiciled are to have jurisdiction. It would lead, in cases other than those expressly provided for recognition of the jurisdiction of the courts of the plaintiff's domicile, a solution which the Convention does not favour, since in the second paragraph of Article 3, it excludes application of national provisions which make such jurisdiction available for proceedings against defendants domiciled in the territory of a contracting state. So again, we get the priority point. And then at 16, which is at 3179, we see an argument that was made by the German government in this case, that the court ought to take account of the national law of tort in order to determine the question of where the place where the harmful event occurred. So they were saying there was a provision of German law that dealt with this, and they thought that it should be, on a subsidiary basis, I assume, left to the courts of the member states to do that. And that argument was rejected. Essentially, it's got to be an autonomous concept. But the basis then as set out is at 18. The Convention did not intend to link the rules on territorial jurisdiction with national provisions concerning the conditions under which non-contractual civil liability is incurred. And this is why I say that the streams of argument cross each other, because when you're talking about the European law cases, you're talking about tort in an autonomous sense, which has been developed by the Court of Justice case law for the purposes of its rule in Article 7.2. You can't then cross the stream and then say that it is also the national law of tort, that which is necessary to complete the action as a matter of English law. I would add that that would be particularly ironic in a case like this, where we all know that Egyptian law applies, and we spent a long time arguing about what that means in practice. The fact is that you can either have the EU line of argument as your rationale for doing this, or you don't, but you can't have both, in my submission. And Lord Sumption is wrong to have crossed the streams in that way, because you can't simply move from one to the other. They're doing different things. One consequence of adopting the EU approach, in my submission, is that you can't kind of keep the genie in the bottle. If you take this approach to the question of harmful event, you've also then got to look at what's the meaning of tort. Because if damage for the purpose of ground 9 is accordance with EU law, then why isn't tort also for the purposes of EU law? And if tort is, then what about the relationship between tort and contract? Because we all know from other cases that the European view of the relationship between tort and contract is very different from what the English common law takes. So where does this, sorry, my lord. So, oh, sorry, I thought I saw your hand up. I'm obviously imagining things. That's right.
Sorry, were you looking at me?
I was. I thought I saw my lord fix his hand up. I'm obviously seeing things.
I don't think I did.
No, well, I'm sure you didn't. Miles, we say that you can see from the reasoning of the court how very deep within the system and the scheme of the Brussels 1A scheme the meaning of harmful event is. And it has now been narrowed to a point where it really is very close to what the English common law was before. They've whittled it back and back, but the reason is that they are concerned about promotion of Article 4 in the overall hierarchy. There's one other related point, if I may, which does slightly arise out of Marinari, so we might as well have a quick look at it, which is about forum non-conveniens. One of the things that you do see in the case law from time to time are concerns being expressed by the Court of Justice, which are classic forum non-conveniens issues, and they're having to deal with them in the interpretation of their gateway because they don't have any other legal tool available. So at 3180 at paragraph 20 of Marinari, they conclude, finally, as regards the argument as the relevance of location of the assets, when the obligation to redress the damage arose, the proposed interpretation might confer jurisdiction on a court which had no connection at all with the subject matter of the dispute. A little bit like the concern that was perhaps being heard in distillers. Whereas it's that connection which justifies the special jurisdiction provided for in Article 5.3 of the Convention. Indeed, the expenses and losses of profit incurred as a result of the initial harmful event might be incurred elsewhere, so that as far as the efficacy of proof is concerned, that court would be entirely inappropriate. So they're beginning to bring in questions about what court is appropriate to hear and determine the dispute into the interpretation of their gateway, which is completely what our scheme is designed to avoid the need for. And on forum non-conveniens, Lord Sumption, in our respectful submission, rather characterises what forum non-conveniens does in his judgment in Brownlie #1. And you see that at 1799 of the E-bundle at paragraph 66. Lord Wilson picks up what we submit is the correct analysis of what forum non-conveniens does. Excuse me. I've lost it. It's this one. Yeah, I'm just being slow. So he sets out there the test from the Spiliada. Is it possible that proponents of the narrow interpretation fail to invest due confidence in the appropriate forum inquiry? Is not that inquiry sufficiently muscular to exclude claims founded only on a tenuous amount of damage sustained in England? Excuse me, Lord Sumption contends in paragraph 31 that the main factor which determines such an inquiry is the practicality of litigation. But in the Spiliada case, cited at 40 above, Lord Gough held 1, the question was not one of mere practical convenience. 2, the court had to take into account the nature of the dispute as well as the legal and practical issues that it raised. And 3, that the fundamental requirement was to identify the forum in which the case might suitably be tried in the interests of all the parties and the ends of justice. Now, we submit that, without going back to Spiliada itself, that is, with respect, a correct statement of the law, but it's also a correct approach to take in terms of the role that forum non-conveniens plays. Yes, my lord, Lord Briggs.
And doesn't your point go a bit further than that? Because in the Spiliada, Lord Gough quotes, I think, from the Aberdeen David, Lord Keith, and saying the natural forum is that with which the action had the most real and substantial connection. So it is for connecting factors in this sense that the court must first look.
My lord,
I
yes.
mean, on that view, forum convenience is all about connection.
My
I
lord,
know
yes.
your opponent said it had absolutely nothing whatsoever to do with connection. There seems to be quite a divergence of view between you about it.
Well, I'm not about to line up judges in coloured corners, but you've seen the basis on which I support my submission. And in answer to a question which was put to my learned friend yesterday, and I imagine arising a little bit out of the Louise Merritt article, with which we were aware before the court kindly shared it with us, but we hadn't necessarily appreciated that it was going to be of direct relevance. So I hope we can be forgiven for not having included it in the bundles in the first instance. But I mean, we take the view that Merritt in that article obviously appears to express sympathy with what Lord Sumption was saying in the minority judgment in Brownlie #1, and springs from unfortunately the wrong platform in terms of what forum non-convenience test is currently capable of. Oh, sorry, Mr. Palmer. Oh, sorry. And therefore, to that extent, we disagree if her conclusion really is that forum non-convenience isn't a suitable tool for establishing sufficient connection. But insofar as she posits an alternate route through this kind of field, we submit that really a lot of the suggestions she makes are quite wide-ranging in character and would require a more substantial legislative solution. I mean, at one point, she does seem to acknowledge the fact that you would end up needing an additional ground of forum of necessity in order to sweep up those cases, perhaps like Mr. Pike, who would be excluded. But that's not obviously an option that's available to this court. So whilst it's of interest and obviously a matter which has taxed academics and the courts a great deal, we would submit that in the context of this case, there's no real and obvious problem with the test that we've got, and this isn't the time or place to be changing it, or certainly not undermining it in that way. Now, I did put in a supplemental note about Brexit, not through any joy of reading through the European Withdrawal Acts and all the associated legislation. I don't know if it reached your lordships. I'm hoping it's not too controversial. I included it because I thought it might be of concern to your lordships whether Brexit had made any difference. We think the position is, certainly on our case, it doesn't make any difference, because we say that there was never any good reason to follow the EU case law in respect of the tort gateway anyway, but insofar as there ever was, there definitely now isn't. But if your lordships are minded to adopt, contrary to my submission, the view that the EU case law is relevant, then we would say that Brussels 1A is no longer any part of English law, that the current case law from the CJEU is now retained EU case law, and the future cases that will go on to be decided by the CJEU under Brussels 1A will not have binding effect. So your lordships may need to give thought to what would happen in such a situation if we are to hitch ourselves to the EU's wagon. And the former interpretive obligation on this court which arose under the CJEU, such as Mar leasing or FIFA, is replaced now, and there is an entitlement to depart from those cases if you think fit. It was intended to assist. I hope I haven't created a whole layer of complexity that we don't need to get into. I guess I would say that on our case, you definitely don't need to get into it, because we say that there was never any good reason to follow the EU case law, and it probably wasn't the intention of the draftsman, so far as we will ever know, in any event. I haven't taken you in detail to all of the cases that were referred to in the written case. There are submissions about the ERAS-EIL judgment in paragraphs 24 to 26 of our written case, which is 119, to which I would invite you to have consideration, and also in respect of the ABCI judgment, that our submission in a nutshell on those is that neither of them has any impact on the finding in Mattel, the central holding that any significant damages in England is enough. And although factually complex, and frankly in some of the reasoning a little bit difficult to follow, they don't actually touch on the central holding in Mattel. In fact, they all proceed on the basis that that decision is correct. Against that background, and a little bit earlier than scheduled, I'm just going to look over to my junior on my left to find out what I've missed. Oh, he's shaking his head. That's something. My Lord Burrows, yes.
Yes, a question that I wondered whether you'd thought about at all is that under the present practice direction 3.14a, it would appear that the issues that we're looking at in this case would no longer be problematic. So 4A reads, a claim, if you're not got in front of you or not familiar with it, a claim is made against the defendant in reliance on one or more of the paragraphs, which then are referred to and include paragraph 9, and a further claim is made against the same defendant which arises out of the same or closely connected facts. Now, as it's not in dispute, or rather I should say it's already been decided that the contract gateway is satisfied, and as these facts are the same or closely connected, obviously, to what the contract claim is, it would appear that as of today, you would win on the gateway applying 3.14a. Now, of course, that came only into effect on the 1st of October 2015, but I wondered if you had any views or had thought about that issue, because it might be regarded as having some impact on the way we view the policies involved.
Well, my Lord, obviously the question of jurisdiction has to be determined as at the time of the original application. So that's why we've all been working on the version of the rules which were in place prior to 2015. So we don't actually have the benefit of them, as your Lord has observed. I suppose the secondary question might arise as to if the same facts were to occur now and somebody in Lady Brownlie's position were to issue her claim, what would happen, and would it matter? I'm not sure I know the answer to that without looking at it in detail, which I'll be honest, I haven't yet done. But what I would say, if I may, is this, that our submission is that shouldn't influence your Lordship's judgment on the tort gateway, for the very simple reason that in some ways Lady Brownlie is quite fortunate to have a contract claim as well. Very many personal injury actions arise in tort alone. And so in our submission, one shouldn't work out from this case on the assumption that other victims will be in the same position as Lady Brownlie. Many will be required to rely solely on the tort gateway in order to establish any potential jurisdiction. Unless there are any further matters with which I can assist the court, those are my submissions.
Can I just ask from a position of ignorance, and I'm looking for assistance. Where, as in this case, there is a claim form and subsequently an amendment of the claim form so as to substitute a new defendant, and permission is sought to serve the claim form on that defendant. Would that be governed by the CPR as it stood at the time when of the original claim form, or as it stood at the time when the amendment had been made and service out was sought?
I don't know the answer to that question off the top of my head. I would need to check. I might need to get back to your lordship on that.
It just occurred to me to ask it in the light of the point that Lord Burrows raised.
Absolutely, but I will. I'm sure I can do that research relatively quickly if your lordship is content to receive an answer closer to 4 o'clock than 3 o'clock.
Oh yes, in fact, I'm not suggesting that you and Ms. Kinsler necessarily have to answer the question today. It'd be useful to know what you think the answer is at some point.
Absolutely.
Thank you very much.
Thank you.
Well, unless there are any further questions for you, then I think we can turn to Ms. Kinsler.
My Lord, thank you very much. I will address the court in reply on the merits aspect of the case. My Lords, I thought we would start with the academics because they are often very valuable to the court in these difficult areas. And my learned friend took the court to Adrian Briggs, an extract from Adrian Briggs' book, which is in the electronic file at 3350. As your lordships know, he is the professor of private international at Oxford. It's always helpful to read what Adrian Briggs says, and he certainly leaves one in no doubt as to his view. But it is important in my submission to read all of what he says on a topic. And so I do invite your lordships to look again at that section, and particularly picked up on page 3353. I think my learned friend took you as far as 3352. But I do direct your lordship's attention to 3353, the penultimate paragraph on the page, which starts, "Now, if this is how it is done, it's legitimate to ask whether the approach which is taken to foreign law is fit for purpose." And perhaps I could invite your lordships to read the end of that paragraph, and then I'll pick up the next paragraph. My Lord, I'm going to pick it up then at the paragraph starting at the party seeking to rely on foreign law. Have your lordships got to that point? The party seeking to rely on foreign law satisfies the judge that foreign law is in principle applicable, but fails to satisfy the judge as to its content. It's sometimes said the judge will still apply the foreign law, but in the sense that foreign law is presumed to be the same as English law when the country has not been proved. Such tosh has no place in the discourse of the law. In the absence of proof of the content of foreign law, an English judge still has to adjudicate. The default position was and is that English law will be applied faute de mieux. But once or twice the courts have been prepared to dismiss a claim or defence as unproven if foreign law pleaded as its support has not yet been established by evidence. my lord, we do rely on that, and characteristically clear, such tosh has no place in the discourse of the law. And in this case, the court does have evidence before it of foreign law. But the trouble is that the evidence doesn't do what the claimant needs it to do. So we're not in the faute de mieux circumstances where the court has no evidence of foreign law. The court does have evidence of foreign law, and in our submission, particularly in the context of a jurisdiction application, which the burden is on the claimant, and the purpose of the test is for the court to satisfy itself that there is actually a viable claim, then the presumption has no role to play. My learned friend also referred to Mr. Fentiman's work. We'll give him his correct title also, Professor Richard Fentiman, Professor of Private International Law at Cambridge, and he is the author of the book, which is at your in the electronic file at 3408. My learned friend describes it as a lament. Your lordship will have noted that it was referred to in many of the cases that we looked at in my submissions yesterday, particularly by the Court of Appeal in Shaker and in Belhaj. And your lordships may think that, given when it was written, 1998, before these cases were decided, that it was rather prescient in its analysis. And in our submission, it articulates a very coherent and appropriate approach for a modern legal system. And for once, I'm happy to say that the academics are speaking in one voice. Professor Briggs clearly takes the same view about the presumption. And I should also note that Professor Briggs is the editor of the relevant chapter in Dicey, chapter 9, which I took your lordships to yesterday. Just moving on then to the test for the merits requirement. We know it's reasonable prospects of success. We know the burden is on the claimant. In our written case, we set out at paragraphs 109 to 115 the history of the test and some of the cases which look at the purpose for the test. And I didn't have time yesterday to take your lordships to those, but I do draw your lordships' attention particularly to the Société Générale case and the other cases cited there, because the focus of the court's attention has to be on the claimant's claim as advanced. That's what the court's looking at, to see if the claimant's claim as advanced has merits. My learned friend took the court to VTB, Lord Neuberger's statements. That was in the context of a defendant raising issues or not, only in the context of foreign convenience. It was nothing to do with the defendant's position in relation to the merits. In relation to the merits, the claimant advances that claim. The court has to decide if that claim has merits. And the claim has to have merits on the facts and on the law. And if English law applies, as most often will be the case, the court will most often just be looking at facts. But in areas where the law is developing, sometimes the court will have to look also at English law. So, for example, in the parent company liability cases like Vedanta and Shell, the court looks in some detail at the state of the law to see if there is an arguable case under English law, to see if there are reasonable prospects. It's not simply a question of saying, is there a killer point? The court looks properly to see if there's a legal basis for the claim. If foreign law applies, the position is different. The court cannot take judicial notice of foreign law. We know that. We put in our written case, it's paragraph 123, footnote 40, we referred to the Court of Appeal judgment in Morgan Grenfell, where the Court of Appeal expresses the hope that at some future time the English court will be able to take judicial notice of foreign law. But that was in 2003, and the position hasn't moved on. The court can only proceed on the basis of evidence of foreign law. If there is evidence of foreign law, the court assesses the merits based on that evidence. And I'll come back to the evidence in this case in a moment. But if there is no evidence of foreign law, what should the court do? Well, the claimant says the court should rely on the presumption that foreign law is the same as English law. And I made my submissions on that yesterday as to why it's not appropriate. But even if the court decided to apply the presumption, it's important to think about what the court is actually doing. And I have two submissions to make in relation to this. First of all, it's not a question of saying, we think any system of law is likely to have a claim in these circumstances on these facts. It may be correct to say that most systems of law will provide a system of compensation for certain facts, but that's not sufficient. Different systems of law provide different types of claim. So your lordships may well know that in New Zealand, at least for the last 40 or so years, there has been a statutory scheme for recovery in place of tort recovery for road traffic accidents. It's an exclusive compensation scheme. So under New Zealand law, there isn't a tort claim. Your lordships will know that in Scots law, the fatal accident recovery is quite different from English law. It's much more favourable. More types of dependents can claim for a fatal accident recovery. It's wider than the English system. And other systems of law deal with fatal accident claims quite differently. The European Court judgment in Lazar refers to the fact that many systems either attribute the claims to the estate or to the dependents, but it's all different. And in my submission, it's very important to look carefully at what the court is doing when it says it's applying the presumption. It's not sufficient just to say, in principle, there will be compensation. It's also not sufficient to say, we'll apply a general feel as to the likely position in foreign law. You need to know the basis of liability. You need to know the scope of the liability. You need to know the recoverable heads of loss, because that's what imposes an obligation on a defendant. As far as the evidence in this case goes, we've set out the evidential position at paragraphs 134 to 146 of our written case. And as our case is that there is no evidence before the court of a claim in contract. Lord Legate is quite correct to say there's no evidence of a claim based on liability in contract which could apply in this case. Both Lord Justice Underhill and Arnold agree on this. It's 143 and 144 of our written case refers to the relevant paragraphs of the Court of Appeal's judgment. And the claimant's expert, having put in two reports, second report says the claimant brings the claim for vicarious liability and tort, and effectively doesn't rely on a claim in contract. The result of there being no evidence of a claim in contract is the court should not give permission to serve out in respect of the contract claim. Albeit that the gateway is satisfied, Lord Burroughs raised that point with my learned friend, so the contract gateway was held to be satisfied on the basis that the telephone call, the contract was made in England on the basis of the English law rules. So the gateway is satisfied, but separately the claimant has to satisfy the merits test on the contract. And we say in the circumstances where the claimant has put in evidence of foreign law, there's no evidence of foreign law for the court to proceed on, and there's no presumption which the court could properly apply in circumstances where it has evidence before it, including the two reports from the claimant's own expert. We say the position is no different on the direct liability and tort claim. Again, Lord Justice Underhill and Arnold agree that there is no evidence of such a claim. My Lords, just on the Fatal Accidents Act point, we say that the judgment in Cox is relevant. It doesn't deal with the presumption, and I didn't suggest it did deal with the presumption, but it does rule on the issue as to whether the Fatal Accidents Act can apply in circumstances where there was an accident abroad and the applicable law is not English law. The difference in Cox with this case is that in Cox, the claim was pleaded under English law and in the alternative under German law. I know because I pleaded the claim, but the result of it was that when the Supreme Court held that there was no claim under the Fatal Accidents Act, there still was a claim under German law. And the question then became as to the assessment of the damages of that claim. And that was the circumstances which the Supreme Court was then looking at. How would you go about assessing damages. This was at a time pre-Rome II, when damages in the English court generally were determined by the law of the forum, English law. So Harding and Whelans had set that in play. And in Brownlie FSHI, the Supreme Court applied Cox to this very point and said there is no claim under English law. My own friend said there wasn't any argument about the presumption. It's in the written cases. It's clearly in the Court of Appeal's judgment. Lady Justice Arden refers to the cases. It's true that there's no mention of the cases in the Supreme Court, but the written case and the oral proceedings show that we argued about these points. And the position is no different on the pleadings now in my submission. The words under Egyptian law simply add nothing to the pleadings. All they do is they demonstrate the claimant's acknowledgement that the only claim they have is under Egyptian law. My Lord, my own friend says it's all a question of procedure and that Rome II and Rome I still commit that. Now, at no stage have I said that Rome I and Rome II require the removal of the presumption or the operation of the presumption. I did submit to your lordships yesterday, and my position is the same, that the rules provide that the court can depart from the applicable law rules in circumstances where the parties agree. And Lord Reid's example of the position in Scotland, where the commercial parties proceed and the court proceeds on the basis of English law without proving any foreign law, is precisely how we say this should operate. If the parties are content to proceed on the basis that there is no difference and that effectively the applicable law can be English law, that's fine, and Rome I and Rome II does not cut across that. But to say it's simply a matter of procedure and evidence is wrong as a matter of private international law. The operation of the presumption affects which law applies, and as a result affects the substantive rights of the parties. And on no view is that a procedural matter. The applicable law defines those rights and obligations, and that's why the court, when it's assessing the merits, needs to look at the relevant law to see what the position is and see whether there is a claim under that law, because that law defines the rights and obligations. And yes, the English court treats foreign law as fact, but it's fact of a peculiar kind because it defines the rights and liabilities. My Lord, in terms of the mandatory aspect of the rules, the choice of law rules at the moment in this case derived from Rome I and Rome II, and obviously they were regulations, EU regulations, which by their nature are mandatory. They're no longer mandatory regulations in the English court, but the terms of those regulations remain the same. They've effectively been implemented in the same terms, so the court shall apply the applicable law as the rules dictate. In my submission, the position was not really any different under the 1995 Act. They were the choice of law rules which the court had to apply. To say that somehow they can be opted out of, by agreement between the parties, but not unilaterally, because they are the rules that apply. My Lord, on the evidence, as a result on the evidence, we say that there is no evidence of a claim in contract, no evidence of a claim based on direct liability and tort. As to vicarious liability, we have always accepted, since at first instance, that there is a reasonable issue to be tried in relation to vicarious liability. We don't accept that liability. It's not common ground that there is that liability established, but we accept there is a reasonable prospect of success. The defences we've indicated we will raise are first the defence of cumul, because the position appears to be under Egyptian law, as the evidence demonstrates that it's a civil law system, and if there is a claim in contract, there is no claim in torts. That's one of the defences we raise, because Mr. Ezo says there is a claim under the contractual commercial code, but it has expired. So we say there's a cumul defence, but it's not a knockout point. And so we don't say there's no arguable case on vicarious liability. We also take a limitation point, but again, we don't say that's a strikeout point. But that's the only only evidence of a claim with reasonable prospects of success before the court. So the question for your lordships is whether to allow the claimant to use the presumption to somehow bring up a claim in contract and bring up a claim in direct liability in tort when there is no evidence of that before the court, despite the claimant having had 2 opportunities to put such evidence in. I return then to where I started yesterday, which is the pleading point. So we say that the only claim which the claimant could properly plead in this case is the claim based on vicarious liability and tort. And she'd need to plead the content of Egyptian law, and she'd need to plead the facts which give rise to that liability under Egyptian law, and they're not the same, the evidence shows, as the facts which give rise to vicarious liability in English law. But we do also say that in the absence of the pleading of foreign law, the claim is not viable and will fail. The claimant's position is clear. She put in her application for permission on the cross appeal because she says she doesn't need to plead foreign law. She's entitled to rely on the presumption. And in my submission, there is nothing in the authorities to support a case that a claimant can rely on the presumption that foreign law is the same when it's not pleaded in circumstances where she relies on that law for her claim. The authorities are to the opposite effect. I took your lordships to Oppo and Belhaj yesterday. My learned friend took your lordships to the Iranian offshore case. I just draw your lordship's attention to paragraph 11(3) in that case, which in my submission supports this point. The judge is making an exception for cases where the claimant is relying on foreign law. It would be significant if the Supreme Court decides to change the law on this point. Till now, foreign law has been required to be pleaded. And if the Supreme Court decides to change that, then that will be a significant step. We submit that would be a retrograde step. The parties are entitled to know the claim against them, and in the English court, the way in which the parties know that claim is from the pleadings. The court, in deciding whether to grant permission to serve out, should also be put in a position to know what the claim is that's being advanced, so that the claim can be assessed, whether that claim has reasonable prospects. It shouldn't be done in a very loose way, it should be done in a precise way. What is the legal basis for the claim, and are there facts sufficient to establish a reasonable prospect of the claim? The foreign defendant, who may be an individual, I mean, I happen to act for a company, but the tort gateway and contract gateway allows the court to summon individuals to the English court. And the individual is entitled to know clearly, just as a company is, what claim is put against them. And it's not appropriate in my submission to summon a defendant to this jurisdiction on the basis of a pleading which would be satisfactory if English law applied, but does not set out a case by reference to the law which all parties agree actually does apply. My Lord, those are my submissions on the merit test. I'm just about to hand over to Mr. Palmer. I can just pick up on Lord Burrows' point about Gateway 4A. My understanding of the position, and also Lord Reed's intervention, my understanding of the position, although we're very happy to check, is that the relevant gateways would apply at the time of the amendment. So that would be the time at which the gateways should be considered. But I say I will check that. But the claimant has not at any stage relied on that gateway. I think the application, the rules provide that the application must set out which gateways are relied on. And I think the application, I'll just direct your lordships to the actual application that was made in respect of this dependent.
Are you telling us that this whole hearing is proceeding on a false premise?
Well, I'm not suggesting that, my lord. I'm not suggesting that. I'm saying it's not relied on, but also I think there are a number of real issues with its potential application. I was just trying to help your lordships. Real issues with its potential application. And if we were to make submissions on that, I would want to do that, not now, obviously, but real issues. There's a number of authorities, because it's quite a new gateway, there's a number of authorities beginning to look at it. but also which gateways apply changes the whole jurisdiction of the equation. So we would want to, I think, make submissions if that was something your lordships wanted us to consider. So I'll stop there for now.
Well, in that case, we'll turn to Mr. Palmer.
Thank you, my lord. I'm afraid my reply may be slightly in a mishmash order, but forgive me for that. I was going to start with the Commonwealth authorities and just refer your lordships to 3 of them. First of all, there's a case called Dynasty, which is at 4764, a decision of the Hong Kong Court of Appeal, which we submit got it wrong as far as damage sustained is concerned, because they did not, first of all, we would say they misinterpreted Metal and Rostoff, but they were not referred to either the case of Ruffer or the cases of Bastoni, Eris Isle, and ABCI. Whilst I'm on that topic, may I just also deal with my Lord Borough's point about the decision in Metal and Rostoff that there was no actual decision that damage was not sustained in Switzerland. I respectfully would submit that had the court thought that damage was sustained in Switzerland, they would have said so. We submit that the position is made quite clear in Bastoni and ABCI that where damage is felt on the balance sheet or at head office, simply because that's where the loss eventually comes to be counted, those cases make it quite clear that that is not sufficient to establish the gateway that damage is sustained in that location. The second Commonwealth authority is one called Fong Chak Kwan, which is a 2020 Hong Kong case at 4813. That is a case which, as it were, follows the majority obiter dicta in Brownlie 1, and with respect, it doesn't carry any additional reasoning or justification for that, and so doesn't assist your lordships. Could I, however, refer to the decision of Club Resort and Van Breda, which is at 1870, and is dealt with in our written case. For reference at paragraph 63 on EF 77, but I won't ask you to look at that. What we say there is that in that case, the Supreme Court of Canada promulgated a list of presumptive connecting factors for claims in tort, which would be sufficient to satisfy the gateway requirement, subject to the presumption then being displaced by the prospective defendant. And what happened in that case was that it was determined that the mere fact that someone is injured abroad and comes back to the country, even though in Canada damage is deemed to include the sequelae of the injury, that would not be a sufficient presumptive connecting factor. So if I take your lordship's to 1870. What do I do? There we are. That's the case. It's one of these ones which is rather complicated, but it could, the head note is at 1871. If I could ask your lordships just to read the bit above the holding to show you what was happening. This is the Supreme Court of Canada. And then if I could go to 1909, paragraph 71, the development of an appropriate framework for the assumption of jurisdiction requires a clear understanding of the general objectives of private international law. The existence of these objectives doesn't mean the framework must be uniform across Canada. Because the provinces have been assigned constitutional jurisdiction, they're free to develop different solutions. What would be an appropriate framework? How should it be developed in the case of assumption and exercise of jurisdiction by a court? And then at 73, given the nature of the relationship governed by private international law, the framework for the assumption of jurisdiction cannot be an unstable ad hoc system made up on the fly on a case-by-case basis, however laudable and objective the individual fairness might be. And then over the page at 70, at the end of 73, the challenge is to reconcile fairness with the need for security, stability, and efficiency, and in the design and implementation of a conflicts of law system. And then at 1911, paragraph 76, the statutes based on Book 10 of the Civil Code for Quebec rely on specific facts linking the subject matter of the litigation to the jurisdiction. These factors are considered in order to determine whether a real and substantial connection exists for the purposes of the conflicts rules. In the CJPTA, in tort claims, section 10 refers to the situs of a tort as a specific factor connecting the act with the jurisdiction. And then going further down, after section 10H, jurisdiction can also be presence-based when the defendant resides in the province. And then the Civil Code of Quebec contains a list of factors that must be considered in order to determine whether a Quebec authority has jurisdiction over a delictual or quasi-delictual action. And then the next page at 79, a clear distinction must be maintained between, on the one hand, the factors or factual situations that link the subject matter of the litigation and the defendant to the forum, and on the other hand, the principles and analytical tools such as the values of fairness and efficiency, or the principle of comity. And then at 1913, the next page, at paragraph 81, the presumption with respect to a factor will not be irrebuttable, however. The defendant might argue that a given connection is inappropriate in the circumstances of the case. In such a case, the defendant will bear the burden of negating the presumptive effect. And so then they come to the list of presumptive connecting factors. And at 82, they say jurisdiction must be established primarily on the basis of objective factors that connect the legal situation or the subject matter of the litigation with the forum. And then over the page at 83, which is, he says, I'll briefly discuss certain connections the courts could use as presumptive connecting factors, and he goes through them. And at 84, I wouldn't include general principles or objectives of the conflict system, such as fairness, sufficiency, or comity, in this list of presumptive connecting factors. And then over the page at 86, the presence of the plaintiff in the jurisdiction is not on its own a sufficient connecting factor. And finally, at 89, which is quoted at length in our case, the use of damage sustained as a connecting factor may raise difficult issues. For torts like defamation, sustaining damage completes the commission of the tort and often tends to locate the tort in the jurisdiction where the damage is sustained. In other cases, the situation is less clear. The problem with accepting unreservedly that if damage is sustained at a particular place, the claim presumptively falls within the jurisdiction of the courts of that place, is that this risks sweeping into the jurisdiction claims that have only a limited relationship with the forum. An injury may happen in one place, but the pain and inconvenience resulting from it might be felt in another country, and later in a third one. As a result, presumptive effect cannot be accorded to this factor. And then the list of connecting factors is in fact set out in paragraph 90, just as four simple situations. So as I say, the court is there accepting as a matter of words, damage includes the injury and its pain and inconvenience, but as a constitutional connecting factor for the purposes of conflicts, it is insufficient to bring you through the first gateway.
Well, it's considering, he was, I think Justice Labelle was considering a test of real and substantial connection, wasn't he?
Yes, I think his starting point was that there must be a real and substantial connection between the tort and the tortfeasor and the country in which you are trying to bring him for trial.
Yeah. Yes, I mean, it's a complete, he's undertaking a very different exercise from us. You see his summary at paragraph 100 on page 1920, where it says, to recap, to meet the common law real and substantial connection test, then the party has to identify a presumptive connecting factor, and he's listed some presumptive connecting factors for tort claims.
Yes.
Yeah.
I mean, it is a completely different system, but it's not one in which, as might have been suggested from the case of Weil, that you simply look at where the pain was experienced after the original injury and say that is sufficient for jurisdiction. Moving on then, if I may, to the same point, but as enunciated in Distillers at 3871, which one we were looking at this morning, in the English jurisdiction. But I would respectfully submit that the case there cited clearly does require the necessary connection. It's at letter E on that page, where I think is it Lord Pearson? Sorry, my lord. At E on that page, where he says of the three possible theories, that it's necessary and sufficient, the last ingredient of the cause of action, the event which completes it, brings it into being, has occurred within the jurisdictions, seems to be wrong as a theory. The last event might happen in a particular case to be the determining factor.
We have been taken to this passage before.
Yes, my lord, I'm sorry. But it does stress 2 points then, and also over the page at 3872, if I could just ask you to look at that passage, D to E, which I think we also looked at this morning, But the passage at E is the right approach is, when the tort is complete, to look back over the series of events constituting it and ask the question, where in substance did this cause of action arise? And that is still, in my respectful submission, the correct approach. When the tort is complete, you look to see where the damage was sustained and look back to see where in substance the tort occurred and where the damage was sustained. But if you then wait for 6 months or perhaps longer, I think in the case of Cooley, and see that the claimant has returned to the UK, when is it that you carry out the exercise of looking back over the series of events? It is clear that the connecting factors must be complete when the tort is complete. On the question of the purpose of the rules, my learned friend suggested that there was insufficient to demonstrate that the rules were amended in 1983 to bring them into line with what was available under the European regime. The clearest demonstration of the purpose of that litigation was that, having been made in 1983, it was expressly required not to come into force until the European regime came into force. So it was clearly intended to go hand in hand with the European regime. It wasn't intended to reverse the decision in Distillers in 1971, because if it had been the intention to reverse what had been the law up until 1983, then it would have come into force straight away. But that wasn't the situation. My lords, there's been a certain amount of confusion about whether it is our case, or indeed whether Lord Sumption suggested that it was necessary to look for the, quotes, damage that completed the cause of action. It is not our case. I confess that it was a suggested submission in the Cooley case many, many years ago. I've been told it's wrong and accept that. It's not what damage completes the cause of action. It is simply the damage or the damage to the bodily integrity which is suffered in a personal injury case. And that is exactly what Lord Sumption said, and did not. He expressly disavowed the suggestion that it was coterminous with the damage which brings about the cause of action, and no doubt thinking of other cases that this rule applies to besides personal injury cases.
Can I
yes,
ask a question about that?
Yes.
I take the last point, but I have some difficulty in reconciling it with your previous submission, that one looks back over the events constituting the cause of action and determines the question at the time when it's complete.
Well, you look at the tort once it is complete and decide whether there are connecting factors.
Well, then what's the distinction you're drawing with Lord Sumption's analysis?
I'm sorry, my lord?
Then I don't understand the distinction you're drawing from Lord Sumption's analysis.
Well, it may be that in a personal injury action there is no real distinction, because that is when the cause of action does accrue. But it is the invasion of bodily integrity, as he puts it, which is what is intended to be within the rule under section 919A. And then Lady Hale suggests that the rule doesn't deal with cases, for instance, where the tort is actionable without proof of damage, with respect, that may be something that Lord Sumption already had in mind, but I'd say a few things about that. First of all, that the concept of a tort actionable in the absence of a provable loss or damage is an English concept, a concept of English law. We are looking here at the concept of damage being sustained in cases where, certainly since the 1995 Act, it's extremely likely, in fact, very, very likely, that it won't be English law that applies to the tort. And certainly since Rome II, it's very unlikely that English law will be applicable to the tort. So to interpret the jurisdictional rule by concentrating on a specific rule of English substantive law, which arises in such cases, would be, in my respectful submission, an error. And I would also, in the same way, of course, there isn't a problem if a tort doesn't create any damage at all, then one would say either it is committed within England, in which case it comes within the rule, or it's committed outside England, in which case it doesn't come within the rule because there's no damage sustained. So I don't think there's any problem with cases which are actionable without proof of damage. But there may be, I think Lord Burrows did postulate a potential case in which direct damage occurs in such a case after the cause of action is complete, and one would accept that that would produce a difficult question. It may well be that it would, in those circumstances, come within the rule. And again, parce Lord Legate, maybe Lord Pearson's suggestion of looking back from the precise moment when the tort is complete would have to be adjusted to looking back from the time when that damage occurred. But it would have to be, in my respectful submission, direct damage and not the sort of damage which is relied on in this sort of case. And I would make the same point with respect to, or the same 2 points in respect of Fatal Accident Act damages. My Lord Burrows has said, well, maybe one should look at the financial loss of dependency which accrues in this country at the moment of death in Egypt. Well, of course, the first point is that the Fatal Accidents Act doesn't apply, and so we don't know precisely what we are looking for by way of remedy for a fatal claim in Egypt. And I certainly know of some countries where the way of compensating for a fatal accident is simply to give the deceased person the loss of earnings for the rest of his life, the rest of his expected life, as compensation for his death, which goes to the estate. So again, I would first of all warn against looking at examples which arise and give rise to questions under English law, and look at it more in a holistic way or a worldwide way. And I would certainly suggest and submit that it would be a seriously wrong turn if one were to seek to move away from the decision in Lazar and under Rome II, that the damage which occurs in a fatal case is the infliction of the injury which causes death to the deceased and not anything else. So, my Lord, we submit that whilst it is possible to look at the word in isolation, damage, and say, well, it includes later pain and injury and later financial loss, that is not the purpose of this statutory gateway. My learned friend was asked by, I think, Lord Leggett, are you saying that financial loss in personal injury is enough? And it was suggested that the answer to that was yes, with the comment from my learned friend that you are suffering the consequences of injury, so you suffer financial loss. Well, that is really the crux of this case and this question. If the consequences of injury going on into the future are to constitute the damage which is required to be found sustained in this country, then that is one answer, but it also demonstrates all the flaws in that case, because A, those consequences may or may not be found at different times in the chronology, and secondly, they are exactly the sort of indirect consequences which are eschewed in the European cases, which this was meant to align with, and which arise without demonstrating any connection whatsoever with the tortfeasor and his tortious conduct in Egypt. My Lord, Lord Briggs, threw out a question regarding the role to be played by forum non-conveniens, and I did have a quick look at Spiliada, and it's at 2623. I respectfully submit that there is no inconsistency. I think we may just need to start at the previous page, 2622. This is, as I recall, is a case of a defendant properly joined seeking to prove forum non-conveniens. Since the question is whether there exists some other forum which is clearly more appropriate, sorry, I meant letter G, for the trial of the action, the court will look first to see what factors there are which point in the direction of another forum. These are the factors which Lord Diplock described in McShannon's case as indicating that justice can be done in the other forum at substantially less inconvenience or expense. Having regard to the anxiety in another case concerning the use of the word convenient, respectfully consider it may be more desirable to adopt the expression used by Lord Keith in the Aberdeen Dava, when he referred to the natural forum as being that which the action has the most real and substantial connection. For my Lord, the action there, in my respectful submission, is referring to the trial of the action, all the procedure that is necessary in order to resolve the action, and not the cause of action. Although obviously that's not irrelevant. And he goes on, Lord Gough goes on, so it is for connecting factors in this sense that the court must first look, and these will include not only convenience or expense, but also other factors such as the law governing the relevant transaction and the places where the parties respectively reside or carry on business. So that's looking at, as Lord Sumption says, the question in the round as to where the appropriate place for trial of the action should be. and is not concentrating on the crucial issue for the gateway test, which is there sufficient connection between the defendant and his conduct and the jurisdiction in which the claimant wishes to sue. Finally, my lords, in respect of the effect of Brexit and my Lord Legate's question whether this house, sorry, not this house, this court should make up for inadequacies of other jurisdictions and provide justice. Our submission is quite simple, that it isn't for this court to determine that this statutory provision can be enlarged so as to protect Mr. Wink from the inadequacies of the Indian judicial system. And it is right to say that as an effect of Brexit, there will be a number of protections provided by Europe which will be no longer available. But it is, in my respectful submission, for the legislature to determine how those might be replaced, and not, it would be quite improper for this court to consider that the meaning of the rule in 9A should now be adjusted so as to make up for such lack of protection. I think there is a system in countries where I think Canada is one of them, where they have a forum of necessity where you can apply because you cannot get justice in any other appropriate forum at all. There are ways in which consumers can be protected, and ways such as under the Odenbright scheme in Europe, that Road Traffic Act cases for tourists can be protected. But that is not, I would respectfully submit, for this court. It is certainly not by reference to adjusting what is the proper meaning of Rule 19A, because, as has been pointed out, it is applicable to torts in general and not simply to personal injury torts or even road traffic or something of that sort. So, my lord, those are our submissions on that. I've gone 5 minutes less today than last time, but Lord Burrows has a question.
Yes, it's simply, if I may, I didn't catch when you were talking about metal and roast off. I think you gave us the reference to a case. I think you were talking about, was it Bastoni and Firminger? Was
Yes.
That yes, and that's at page 3641. I believe the passage you're talking about is at 3649 of Mr. Is that correct? Is that the reference?
Let me have a look. I think I did take it to you yesterday.
Yeah. Well, sorry, I didn't want to waste your time now. I just thought you might be able to confirm that.
Let me see. I'm sorry. There we are. I'm sure it is, my lord.
Right. Okay. And could I possibly just take the opportunity to ask Ms. Crowther, at paragraph 117 of your written case, you're talking about a cross appeal, which we've had no reference to at all. And I just wanted to be sure that that is still part of your case.
Absolutely, my lord. If I didn't give the general endorsement to everything that's in the written case in the course of my submissions, then that's an omission on my part. Yes, it is. I would caveat that by saying it's something of a belt and braces cross appeal. We don't believe that anything fresh in terms of issues arises out of it.
Thank you.
Sorry, my lord, Lord Burrows, I've now found my highlighted passages from Bastoni, and it was the bottom of page 3649, going over to the first 3 paragraphs of 3650.
Thank you very much.
Well, thank you very much, Mr. Palmer.
Thank you, my lord.
If there are no further questions, I think the only remaining matter is to set a timetable for any submissions you want to make in relation to PD6 paragraph 4A, the point that Lord Burrows raised. Would you be able to give us those within 7 days?
Yes, my lord.
I think really for my learned leader to deal with it, because I haven't been involved in the case until, well, from between Brownlie 1 and yesterday. So
Yes, I'm sure that would be fine. Thank you, my lord.
Might I bravely suggest that it might be sensible to have them staggered so that we go first, given that obviously it's my burden on the underlying application. I mean, I'm happy to go second if my learned friend would rather go first, but it might save some trees or electronic trees, whatever the equivalent is, if we do it sequentially.
Well, if we say 7 days for yours and 7 days thereafter for the respondent to respond.
Thank you, my lord.
I beg your pardon, for the appellant to respond. Fine. Well, we're grateful to you for your submissions. This is a very interesting case on both points. We'll take time now to consider our decision. Court will adjourn.